looks like everyone is slowly coming in, so go ahead and get started. Just a few housekeeping items. This week we have launched a new Q&A tab. So if you look at the top, you'll see a little icon that says Q&A. It's got a little s- bubble with a question mark in it. All questions, if you could please type your questions during the presentation, and that Noelle will get to as many as possible at the end. So let's kick it over to Noelle. Noelle is a shareholder with our firm based in the Houston office. She practices in our Community Association Law section and was just recently awarded the Rising Star Award from CAI National. All right, Noelle, turn it over to you.
Thank you so much for that wonderful introduction, Kyle. Good morning, everyone. Thanks so much for joining us today for our DRV Enforcement 101 presentation. I'm so happy to be here with you today. Again, my name is Noelle Hicks. I'm a shareholder in our Houston office here at RMWBH. Today, we are going to get into some basics about DRV enforcement. Go ahead and go to the next slide. I'm going to give you our disclaimer. I'm sure you guys have heard this before, but just so that we can put it out there, the information presented today is based on the law as it exists as of today, May 18th, 2022. The information presented is for educational purposes and does not constitute legal advice. If you need legal advice relating to any of the topics discussed, please consult your attorney. So what are we going to cover today? What are our goals for today? We are going to talk a little bit about dedicatory instruments. We will talk about creating and enforcing governing documents, some common violations that you may see in your communities, the self-help provision that may be in some of your governing documents, and then a couple statutory requirements. So let's dig right in. So what comes to mind when you say Texas? Well, some people may think of gun-toting cowboys. I know when I was younger, my cousins in Virginia were convinced that I rode a horse to school every morning. Some people might think of, high school football, Friday Night Lights. That's always a big thing. For us, though, in the community association industry, property rights are probably in the top 5 things that we think about. It's widely known that Texans are very serious about their property rights and their freedom to do what they want with their own property. So regulation of land use, as we all know, can be a very touchy subject. Here's a quick story. My parents actually live in the 3rd Ward area of Houston, which is near downtown. This is not a deed-restricted community, so since its inception, property owners have had the freedom to kind of do whatever they wanted to with their properties. Well, recently, a developer moved into the community and has purchased a couple of properties and then submitted an application to have the city designate the area as a historic district. The historic district designation is akin to deed restrictions. It's a little bit more stringent, but as you can imagine, the uproar that it has caused in the community. There's been a lot of news media coverage because the owners feel like the city is unfairly infringing on their property rights. But now in contrast, many individuals believe that to preserve their property rights, they should be able to regulate not only what is done on their property, but what their neighbors are permitted or prohibited to do on their lots. Thus, there is an inherent conflict, right? Back in the day, developers instituted restrictive covenants and then mandatory membership in community associations to do just that, regulate what all owners in a particular community were and were not able to do on their properties. So this actually stems back to, I said back in the day, we're talking about like 1922 here. There was a court in this case, Curley versus Walker, which held that an owner burdens his own land with restrictions because of the fact that a like burden will be imposed on his neighbor's lot. So it would be beneficial to both lots. So the idea of restrictive covenants was mutually beneficial. Of course, then we needed rules to govern community associations. And those rules are contained in what the property code calls dedicatory instruments and defines them as each governing instrument covering the establishment of maintenance and operation of a residential subdivision. These are all documents that I'll talk about a little bit going forward, but it's things that we all know and love that help kind of govern the communities that we manage and that we deal with. So for community associations, the governing or the dedicatory instruments actually dictate the manner in which the community will be governed, right? We also refer to these as the controlling documents. And in order for those to be effective and enforceable, these documents have to be recorded in the real property records for the county in which that community sits. So for example, some of the governing instruments or the dedicatory instruments or governing documents I'm talking about, the plat map. The plat map actually outlines the boundaries and lots of a subdivision. It illustrates any association-owned property, amenities, easements, reserves, etc. The association, which is generally a nonprofit organization, is created by Articles of Incorporation or Certificate of Formation, which gets filed with the Texas Secretary of State. Of these documents, arguably the most important, of course, is the declaration. This document contains important rules like use restrictions, assessments, creation of an ACC where applicable. It also gives the association the authority to create rules, regulations, and guidelines for the benefit of the community. Of course, the bylaws dictate items like the number, election of, and positions on the board of directors, annual meetings, notice requirements, powers of the board, quorum, etc. So I mentioned guidelines, rules, and regulations. Those are some other supplementary dedicatory instruments. They may include architectural or builder guidelines, other rules and regulations that I'll talk about later on that are promulgated by the board. And again, to be effective, these documents have to be recorded in the real property records in the specific county where the community is. I actually recently had an association come to me with various iterations of bylaws that, had kind of evolved over time. And the board was using those bylaws to govern its official association business. But the problem was that none of those bylaws had actually been recorded. That actually makes things really complicated because we can argue that the association has ratified and relied on those unrecorded bylaws for however many years that they were in existence, but it's an uphill battle if they are to be challenged at any point. So that's why it's really important for things to be recorded. So in addition to the governing documents that I'm talking about, we are also subject to state and federal law. Here are some of the relevant ones that we deal with. Of course, there may be some municipal ordinances that are important. And then again, since the association is a nonprofit organization, it's also governed by Section 22 of the Business Organizations Code. Of course, we rely heavily on various sections of the property code like Section 5, 82, and 81 that talk about condominiums, and then 209, that you guys are all familiar with. Then we would look to the finance code to determine the appropriate amount of interest for delinquent assessments when the declaration is silent on that issue. And then also there are several federal statutes that we are subject to. And of course, the federal statutes themselves could be a whole presentation, but just to name a few, the Fair Debt Collection Practices Act, the Telecommunications Act of 1996, the ADA, and then the Fair Housing Act are all very important things that we have to kind of refer to that govern the associations as we know them. So, but back to dedicatory instruments, since laws and technology are ever changing, for example, the 2021 legislative updates that we were all subjected to, our governing documents or our declaration must be a living document. That means that it must kind of evolve with the times. It must evolve as technology changes, and it must be capable of amendment. These are really important. Sometimes the amendment threshold is kind of high. It makes it a little bit prohibitive, but the dedicatory instrument itself needs to have a mechanism by which it can be amended because, again, this is a document that has to change along with how everything in the world changes, how community changes, so on and so forth. But ultimately, we have to remember, go ahead and go to the next slide. We have to remember that the purpose of restrictive covenants is to protect and preserve our property values. This can be difficult to keep at the forefront of your mind when you're dealing with the various challenges that come with management. But it's really important in areas where there's no zoning, such as here in Houston. In that same vein, and in an effort to, again, protect and preserve property values, the community association has to enforce these restrictive covenants by which it is governed. The authority for them to do so is found in, of course, the Texas Property Code, and then in a duly recorded set of restrictions. So we're going to get into the Texas Property Code and the restrictions a little bit. I want to kind of dig a little bit deeper into creating and enforcing the governing documents. So first, like I mentioned, let's talk about restrictive covenants. If you were asked to explain restrictive covenants in 3 sentences, here's what you say. Restrictive covenants state what action is permitted on real property. They state what action is prohibited on real property, and then it designates the persons, entities with rights to enforce either action. Got it? Those are the simple 3 things that restrictive covenants do for us. So on the next slide, we're going to talk about some examples of restrictive covenants that you might see. I know I've seen all of these contained in governing documents such as declarations, but for example, the prohibition against non-residential uses of property. So this one is like a really hot button topic. There's a lot of case law and actually some cases in the Supreme Court that are dealing specifically with short-term leasing, which could potentially be classified as a non-residential use of property. It's important because sometimes restrictions say that, you know, there can be no business activity, specifically saying that there can't be something like a group home or something like that, which may or may not be a violation of the Fair Housing Act. But this is one of the restrictive covenants that we deal with quite a bit because it's kind of a controversial topic. Also, prohibiting multifamily occupancy. So generally, you will have a restriction for single family use only. The requirement that improvements have to be maintained. So that's to make sure that the driveway is not cracked. That's to make sure that the gutter is not hanging off the side of the building. That's just to make sure that in general, the outside of the property is maintained according to the aesthetic of the community. And then also a requirement for architectural review. And kind of the purpose of requiring architectural review is so that improvements that homeowners make and then, you know, apply to make are in harmony with the exterior design of the community and in harmony with colors in the area. Sometimes in the restrictions, there are specific types of exterior design or specific types of color. Sometimes there aren't. And so if someone comes to you with an application and they want to paint their house blue, it's kind of up to you to go into your governing documents and say, well, you know, it says that we have to have neutral tones, or you look around the community and say, oh, well, everything else is neutral tones, so we can't allow you to have a blue house, right? So these are just kind of things that you have to go into your documents and evaluate what's contained therein, evaluate the harmony of the community, and just make sure you're making good decisions based on that. So we have to, you know, enforcement of the restrictions by community associations is really important. So we have these restrictions, they govern the community, but how do we enforce them? How do we make sure that every property owner in the community is abiding by the restrictive covenants? Well, Chapter 202 actually gives property owners associations the authority to enforce. And kind of to summarize, Section 202.004B of the Texas Property Code, the association or even a designated representative can file suit or initiate an administrative proceeding to enforce the restrictive covenants, or in an effort to protect, preserve, or even to protect the operation of property covered by the dedicatory instrument. So, of course, the association has the authority to do that, but then also this section of the property code gives a designated representative, someone designated by an owner of real property, the authority to do that as well. I'll talk about that a little bit more in just a second. In addition to what I just talked about as far as enforcement, Section 5 of the Texas Property Code authorizes a prevailing party in a suit for enforcement to recover attorney's fees. This is really important because the property code lays out certain things that have to be done, certain conditions that have to be met prior to an association being able to seek recovery of their attorney's fees. So, of course, you want to get with your attorney to make sure that you're doing the right thing as far as, you know, being able to recover your attorney's fees in the future. But there are very specific steps, very specific procedures that you have to follow in order to make sure you can get this done. Now, generally, the declaration will contain a provision which authorizes property owners themselves to enforce use restrictions, but there are exceptions. So before we were talking about enforcement by the community association, now we're talking about enforcement by individual owners. So an individual owner can go about enforcing the restrictions, but they can't enforce lien rights in favor of the association, and they cannot enforce rights regarding assessments retained by the association. So, for example, an owner, a neighbor, if they for some reason find out that their next door neighbor is not paying their assessments, they can't go in and try to enforce collection of the assessments. They can't go in and try to enforce the obligation for this owner to pay assessments. That's something that's left up to the association. But when we're talking about use restrictions, an owner is able to enforce that against another owner. But who institute the enforcement action depends largely on whether or not the violation affects the community. The association should, of course, handle enforcement of a community nuisance or something that affects the entire community, but individual owners may seek to enforce a private nuisance. Sometimes we refer to this as a neighbor-to-neighbor dispute, or if it's something that's like only affecting a couple of neighbors that are surrounding this one lot, that might be something that those individual owners might want to take up. Now, when enforcing the restrictions, there is a presumption of reasonableness. The association obviously has the discretionary authority to enforce a restrictive covenant, and that is presumed reasonable under Section 202.004A of the Texas Property Code, unless the exercise of that authority is deemed to have been arbitrary, capricious, or discriminatory. Now, we'll talk a little bit about what those words mean in just a second, but because of this provision of the Property Code, most of the defenses to deed restriction enforcement cases that I see involve a claim that the association should not be allowed to exercise its authority to enforce because it was done in an arbitrary, capricious, or discriminatory manner. In other words, the attorney for that homeowner is arguing that the association has waived or abandoned its right to enforce. There are other defenses, but let's just go over these words: arbitrary, capricious, and discriminatory. So arbitrary means failure to exercise honest judgment. Capricious means freakish, whimsical, fickle, changeable, unsteady, and arbitrary. So obviously this is kind of like a synonym to arbitrary, but really to focus on unsteady is kind of important here, and then discriminatory, which is failure to treat all persons equally. So these three words, arbitrary, capricious, and discriminatory, again, are commonly used in defenses that we see from owners who have decided that they don't want to abide by the deed restrictions. But this is all kind of goes towards the argument that the association has waived or abandoned its right to enforce the restrictions. There are other defenses as well. So, of course, we know that the statute of limitations for enforcing a deed restriction violation is 4 years. However, there is an exception that's called the discovery rule. And the discovery rule basically says that if the association had no idea of this violation, so essentially if it has just observed the violation or just become aware of the violation, then it has an argument that the statute of limitations may not have told. So for example, there is a community that's a heavily wooded community and it's huge, and maybe sometimes the person who's doing the inspections doesn't always get to every portion of the community. And one of the homes has built a tree house in its front yard. But the association has no idea that this tree house is in the front yard, but it was built in, let's just say, 2010. Obviously, the statute of limitations has passed. However, if the association is able to argue effectively that they didn't realize that this treehouse was there until 2020, for example, then an argument can be made that the statute of limitations doesn't apply and that this owner should be subject to the restrictions and the enforcement can proceed. Another defense is called latches. Go back for just a second. That is an equitable defense. And it really means that the association would be barred by recovery because of its undue delay in seeking relief. This kind of goes hand in hand with the statute of limitations. But again, it must be reliant on the plaintiff's undue delay. Undue delay is really kind of hard to prove up because you have to show that it was actually undue delay, right? You have to show a reason why it took the association until 2020 to realize that this treehouse was in that property owner's front yard. So then again, waiver and abandonment are also defenses. So let's talk about waiver a little bit more. It actually warrants a little bit more discussion because it's literally one of the most common defenses we see. So waiver can mean two things. It either is that the association acquiesced to such substantial violations within the restricted area as to amount to abandonment of the covenant, or that there was a change in conditions in the restricted area or surrounding area such that it was no longer possible to secure any substantial degree of benefits to be realized through the covenants. Now, again, this is something that we see all the time. This defense comes up literally in every answer, every affirmative defense that I get, but it is something that is difficult to prove. Go to the next slide. The reason why it's difficult to prove is because the defendant, in this case the homeowner, has the burden of proving that there was a waiver of a provision or several provisions or of the entire set of restrictions that, and then there's a reasonableness test, right? So would a reasonable person conclude that the restrictions had been abandoned based upon the number, nature, and severity of other existing violations? And part of the reason why this is so difficult to prove up is because the owner has the burden to show that there is a specific number of individuals who, aren't compliant with the restrictions, and that it's so severe that, a reasonable person would conclude that the association has just completely stopped trying to enforce the restrictions or this specific restriction or this specific provision. There is a specific percentage that they have to prove up. It's just a very difficult defense. But not to say that it's not something that could be, that they could prevail on, but it's just very difficult to prove waiver. Another reason why it's difficult to prove waiver is because a lot of times homeowners have no idea what stage of the enforcement a particular lot may be in. So it may be the case that the association has not noticed this particular violation, or the association has already sent a violation letter, or that it's at the stage where it's being enforced by an attorney. It might be in litigation. It's very difficult to tell. So again, this is a hard thing to prove. So we've talked about enforcing the restrictions, creating and enforcing the restrictions, but what are some common restrictions or common violations that we might see in our day-to-day practice, everyday goings on or whatever? So a lot of times we see lawn or landscaping maintenance is a major issue. This kind of goes hand in hand with exterior maintenance. But again, part of the reason why there are restrictive covenants is because everyone in the neighborhood has bought into a community and they feel like it's important to protect and preserve their property values. So for example, I have a community that's out in North Houston. It's a little bit beyond Houston, but out 45. And this, when you drive into the community, and actually I like to kind of go into the communities myself sometimes when there's an egregious case of exterior maintenance or lawn maintenance that's not happening, to just kind of get a sense of what the rest of the community looks like and compare it to what this one property that we are seeking enforcement looks like. If I could show you guys pictures of this, I would, but it is an understatement to say that the property is a complete jungle. There are trees growing all over the place. There's vines hanging all off the front of the house. All of the bushes are overgrown. There's no grass on the ground. And instead, there are fallen leaves from autumns past, just kind of like piling up on the ground. There are wildflowers and wild bushes growing everywhere. And it 1000% does not comply with the rest of the aesthetic of the association. Now, the problem is that the restrictions themselves are not very specific. They basically say that the property just needs to be maintained in a certain manner, right? In a healthy, sanitary, the language manner. And so the homeowner and their attorney are making the argument that the wildflowers and the vines are being maintained in a healthful and sanitary manner. And the association is saying, no, it's not. Look at this. It looks like, a large animal could jump out of your bushes at any moment and no one would know that it was living back there because they're so thick. So it's really, it's interesting to see. And it really depends a lot on what the language of the restrictions are. So a lot of times we also encourage our clients to make sure that if they are going to go through the process of amending their restrictions or creating rules and regulations, of course, not in the sense that they want to create a new restriction in these rules and regulations, but to make sure that they're specific about what they want, specific about, there needs to be grass on the ground, or the bushes can only be up to a certain height. What type of plants can be planted? Trees branches can't be so long that they're touching rooftops or, what have you. Those kind of specifics in the restrictions are very helpful, because then you don't have a homeowner coming back and trying to say, well, the restrictions don't say that, so we can't, you guys can't enforce that. Another issue that we see a lot is a homeowner has gone and made improvements to their property without seeking architectural approval. Now, a homeowner is always going to say something like, I didn't know I needed to seek architectural approval, right? And oftentimes, instead of them saying that, they're going to say, well, I did try to seek architectural approval. They didn't approve my application, so I went ahead and built what I wanted to build anyway. That is not allowed. They can't do that. So this is something that we see often. A lot of the more complex litigation matters that we have deal a lot with architectural approval. One such case, for example, an owner built a full outdoor kitchen in their backyard without seeking architectural approval. And then there's kind of like a conflict there, right? Because you're going to court, you're trying to get this person to comply with the restrictions, but do you have them, tear down everything that they've built? A lot of times courts won't allow that, because the amount of money that they have spent to get it all, installed, and then the amount of money that they would have to spend to tear it all down is not necessarily worth it. So it's kind of difficult to figure out what the remedy or what the relief would be in that kind of situation. Also, I have seen quite a bit of parking violations, and people may think that parking violations are minimal and not really that important. Unfortunately, though, parking trailers or boats or RVs on the streets are a huge nuisance, because it makes it so that maybe emergency vehicles can't get through, and it kind of just is an annoyance to neighbors who are maybe trying to, drive out of their driveway and there's a trailer across the street and they don't want to hit it. So this is a kind of big thing. The trash cans are a huge thing, and then just general nuisance annoyances. These things come up a lot. All of these violations come up a lot. And again, it's really dependent upon what the restrictions say and how the language is worded to determine whether or not, you can enforce it or you can't, and then to what extent. So not all restrictions have the authority for self-help, but if the restrictions do, then we recommend that the association exercises its authority for self-help. But before it does that, there are certain notice requirements per the governing documents. Generally, the governing documents will say something like a letter needs to be sent to the homeowner to let them know that there's a violation on the property, and that if they don't correct the violation within the next 10 days, for example, then the association will take it upon themselves to go onto the property and correct the violation, and then charge whatever costs were associated with the association fixing it, whatever it had to pay to the contractor or the landscaper or whatever, put those costs on the homeowner account. Sometimes the homeowner or those charges can be secured by the association's lien on the property in the same manner that assessments are. But it depends on the type of violation and whether or not I would actually advise the association to use self-help. So when we're talking about lawn maintenance issues, that is something that is not so invasive that you can, I would go ahead and advise the associations to do it. There's a lawn maintenance situation that's completely out of control. The homeowner is not doing a thing about it. All of the neighbors are complaining. There are maybe rodents or snakes or what have you. I would go ahead and advise the association to exercise its authority for self-help to get that lawn maintenance done just for the benefit of the rest of the community. But if there is something that's like, the shutters are hanging off the front of the house, or the gutter is hanging down, or something like things that have to do with the structure itself, I would not recommend that the association actually exercise its authority in that situation, because you don't want to expose the association to any sort of liability that might be associated with making those repairs. So lawn maintenance is usually okay. Anything else is kind of a case-by-case basis, and I would generally not recommend doing that. There's also a difference between can and should, right? You should, maintain the lawn because it's a nuisance, and if the person next door is trying to sell their house, potential buyers come in and see that the next door neighbor's lawn is 10 feet tall, they're not going to want to purchase the property. And if the association can, it's a completely different situation, they should definitely make sure that they weigh the options with their manager and perhaps even get the attorney involved if necessary. There are, again, I was talking about the cost of self-help. There's sometimes in governing documents, it basically says that the costs associated with self-help can be secured by the association's lien. Sometimes they're not, so you just need to make sure you understand, if they're secured or not. And then you kind of run across the issue of a person getting upset that you've come onto their property, right? So even though you've sent that notice that's required per the governing documents, given them that time frame, that 10 days, to go ahead and correct the violation themselves, and they haven't done it, you have the landscaper coming. They show up to the property to cut the grass, and the homeowner comes out and yells at them or waves a gun at them or something like that. So those are the kind of risks that are involved with self-help. So again, you just kind of have to take it on a case-by-case basis and really assess the situation to figure out what is right in that particular set of circumstances. So the property code tells us what are uncurable versus curable violations, things where the restrictions have to be enforced in different ways. So what are uncurable violations? An uncurable violation is something that is not a continuous action, or it's a condition that's not capable of being remedied by any affirmative action. So, for example, if a person is shooting fireworks, or it's a noise violation, like a party, one instance of property damage, or like holding a garage sale or something like that. These are all things that are not continuous, something that happens like in this, once in the scope of time. So it's difficult, a little bit more difficult to enforce things like this, but and also it's hard to document things like this, but still these are violations, things that might be worthy of enforcement. Also, an act constituting a threat to health or safety falls within this category. And again, this is something that could occur once within the scope of time. So it's a little bit more difficult to actually enforce the restrictions on these kind of violations, but they are violations nonetheless. So, the common violations that I was talking about kind of fall within this category of curable violations. The list of both of these curable and uncurable violations can be found in section 209.006 of the property code. These include those parking violations that I was talking about, maintenance violations, failure to construct improvements with approval from the association, ongoing noise violations. So when we're talking about noise violations, instead of just like a party one Saturday night, an ongoing noise violation would be like a dog that's constantly barking, that's something that can be documented, that can be presented to the association, because ultimately, if this violation, the owner just completely ignores the association's efforts to enforce the violation or to get them to correct the violation and it comes to us, then I need to be able to have some sort of documented evidence of the violation itself. Because if I have to go to court, I can't bring the judge out to the property with me, right? So I need to be able to show the judge pictures of the violation, a video recording of it, a sound recording of it, something to impress upon the judge how important it is that this violation gets corrected, because it's really interfering with the community and interfering with other neighbors' quiet use and enjoyment of their property. So in addition to the governing documents, for example, the declaration, bylaws, articles of incorporation, so on and so forth, associations have authority to create rules and regulations, like I mentioned, guidelines, but also policies. And there are some statutory requirements that we believe warrant a policy. So as you know, most of you know that last year there were a lot of changes, a lot of legislative changes that affected property owners associations, things that completely turned what we previously thought on its head. So for example, religious displays. So instead of, before September 1st, 2021, people were allowed to have a religious display like on their door, or, something small on their door. Now, a person could actually put a religious display in their front yard, and it could be 6 feet tall if they wanted it to. Another new requirement after September 1st, 2021 was the allowance of installation of certain security measures. So like security cameras or perimeter fence, these are all things that were not generally accepted in community associations that now the Texas legislature has said that we have to allow. So the problem with that is that if we just allow those things and don't regulate them at all, then they could go completely haywire, right? So there are still some, even though those things are allowed, there are still some ways for those things to be regulated, which is really important. So if you want to regulate these certain items, especially things that don't necessarily come from the declaration but are statutorily required, then you have to put a policy in place to make sure that all of the homeowners have something to look to understand what those regulations would be. So for example, with security measures, even though you have to allow a perimeter fence, and by perimeter, I mean a fence that goes around the entire lot boundary, you can regulate the type of fence that gets put up. And how you do this is you require the homeowner to submit an application to the Architectural Control Committee, and you have them list out certain things like the material that's going to be used on the fence, the height of the fence, so on and so forth. And then you could even potentially prohibit or say that, you know, certain fences are not allowed. So for example, maybe you don't want to allow chain link fences. So you could put that in your restrictions. Or maybe you only would want perimeter fences to be made of wood, or maybe you only want them to be black. Those are certain things that you can put in the restrictions that can be regulated under the statute, just with the understanding that the security measure itself cannot be completely prohibited. Another thing that is really important is 209 hearings. So most of you know, and we'll talk about this in another presentation, but just to kind of touch on it a little bit, the property code allows for a homeowner who is being, sent a notice violation or, being told that they have a violation on their property. They're given the opportunity to request a hearing with the board, which we call a 209 hearing, or even a hearing with the Architectural Control Committee to kind of discuss the violation, give their side of the situation, and the board can either, can review all of the information that they're given and either deny or approve the application based on what the homeowner has said. Well, you need to have certain procedures put in place in order for those 209 hearings to go smoothly. In addition to the hearing itself, there are certain notice requirements, there are certain timelines that have to be followed to schedule the 209 hearing, so on and so forth. So all of those procedures, all of those notice requirements, timeline, the actual hearing itself need to be put into a policy so that everyone kind of understands exactly what would go on, exactly what to expect. And so that in the event that there is some sort of litigation, then the association can point to its policy, which again has been recorded in the real property record. So it's completely enforceable to say, we had this policy in place, we followed the policy to a T, and then it kind of gives you a little bit more leverage in those situations. To kind of just touch on the political sign and displays, we are all aware of the election code, the section of the election code that allows homeowners to put political signage in their front yard. There's a certain size the sign has to be, but what's really important is the time period, right? So the political sign can be there for up to 90 days before the election, and then 10 days after the election, and then it needs to be taken up. So while that election code may be widely known by homeowners or by community associations, it might be a good idea to also have a policy for political signs and displays, so that in this like highly politicized era that we're in right now, and how there's a lot of polarizing going on as far as political matters are concerned, everyone knows that you are, if in fact a sign is left in someone's yard the 15th day after the election is over with, the homeowner can't make the argument that you are singling them out because of the candidate that they're supporting by telling them that they need to take up their sign. So it's important that if you have that, you have that in policy in place, so the association can say, no, that's not the case. What we're doing is just making sure that we are uniformly enforcing the restrictions. Not only did we tell this neighbor that had his sign out for 15 days after the election that it needed to come up, but also this neighbor with a different political sign, that one needed to come up as well. So it makes it so the association has a lot more protection, leaves a lot less room for litigation, even though litigation is going to come up. It just makes it so everything is a lot more, tight. There's rules and regulations put in place, and everyone kind of knows what to do. Another rule that has been promulgated by the legislation is that the association has to have a website now where all of the governing documents are listed on the website. It doesn't say that these, policies, rules, and regulations actually have to be there, but it's a really good idea to just have them there. The purpose of that is so that people that are coming into the association, buying into the association, can see that there are deed restrictions, all these rules and regulations that are associated with purchasing this property, and they can't make the argument later on if they don't pay their assessments that they never saw the restrictions, or if there's a violation, they didn't seek approval for something that they never saw the restrictions and never saw the requirement to do that. So, in conclusion, rules and restrictions are going to vary from association to association. They're going to vary from, residential subdivisions to condominiums. They're going to be different. Every community is different. Every homeowner is different. You got to make sure that you have rules put in place that are specific to your community, that go along with the aesthetic of the community, so that you can manage and govern all of the lots in this subdivision in a way that can't be questioned. Of course, enforcing violations should be equal for everyone in the community. That that kind of goes without saying, but it just makes it so that that argument that we were talking about arbitrary, capricious, or discriminatory, it'll be difficult for someone to bring that up. It also makes it so that the association doesn't have any liability that comes from perhaps a violation of the Fair Housing Act. And then also we need to make sure that we are reasonable. So instead of jumping to conclusions on every violation or every time a homeowner comes to the association, requesting a hearing or something like that, instead of judging, instead of making rash decisions, we need to make sure that we review all of the information, give the homeowner the opportunity to have that hearing if they request it, and just be reasonable, because that can really go a long way. So that is all I have for you guys today. I'm going to go into the question and answer portion and kind of see if there's anything here that I could answer. Okay, so the first one, when would there be a situation where a homeowner has a hearing with the ACC? My understanding has been that the ACC makes decisions, and denials are appealed to the board, not the ACC itself. So this actually depends on what your governing documents say. So anytime a homeowner, so to answer your first question, anytime a homeowner requests a hearing with the ACC, the hearing has to happen. So if you're sending them a notice of violation, that notice of violation, if it complies with Section 209 of the Property Code, it should contain a provision in it that says you are entitled to a hearing before the board, and then give the owner how they can request that hearing. If the owner does request that hearing in writing according to the instructions that they've been given, then that hearing should actually absolutely happen. Now, depending on what the restrictions say, the homeowner is either appealing, and again, an appeal may be different than a 209 hearing, right? A 209 hearing can just be a discussion about, even before there is an application for architectural review. Sometimes when they're getting the notice, it's because they didn't submit the application for architectural review. Now, if they get a denial from their application, then they can appeal that. And depending on what the declaration says, it can either be appealed to the ACC or to the board. And then some associations they can appeal it to the ACC. And if they don't like what the ACC has said, then they can appeal it to the board. I hope that answers your question. All right, how does the security measures relate to keeping a pet safe? ACC appeal states making a fence taller is protect their cat from wild animals in the greenbelt behind the home. So this security measures, in my opinion, don't relate to keeping a pet safe. And if there is a provision in your security measures policy that says that the fence needs to be a certain height, then the fence needs to be that height. I don't have any reason in my mind why the fence height would be related to a pet safety issue, but that's kind of like a case-by-case situation too. I'd have to look at the totality of the circumstances to kind of answer that question. All right, Rich said, I thought SB 1588 changed ACC hearings. It did, and The statute is very clear on how ACC hearings should be run. There's very specific procedures, and those are all set out in the Texas Property Code. All right, if the documents state for single-family use, how can the HOA enforce crash pads renting to multiple tenants at a time? So this kind of goes along with like an Airbnb kind of thing. So the argument that we use is single-family use is essentially like the single family, right? And I think this is different from transient use. This is an explanation that will take a little bit longer than what we have, but this is something that certainly can be enforced. But first of all, we need to look at the language in your restrictions to just kind of see what that language is. And then we would also look to the definition for single family use. And a lot of times courts have interpreted it to mean two different things, right? It can either mean the structure or it can mean the actual use, like if it's just, let's say, for example, 4 people living in the house. But if the association's restrictions prohibit like short-term leasing or, those kinds of things, then that's something that you can use to enforce it. But in general, I feel like you can use your single family use restriction to enforce that, but you just have to be careful about what the language says and like the circumstances themselves. How far in advance does the HOA let the residents know of any state rules changing? Okay, so this kind of depends too, and I know you guys probably hate that, but that's like the typical lawyer answer, right? This depends. So, for example, when we had all those changes with the legislative update, the 87th update from last year, the board itself, depending on what the bylaws say and depending upon our interpretation of the Texas Business Organizations Code, the board can adopt certain policies, certain rules and regulations, can even amend the bylaws, perhaps, to incorporate new rules into the community, incorporate new policies. With that being said, it's a good idea to make sure that homeowners know that the board has incorporated these new rules. And so maybe after they've been adopted and recorded, it can be, blasted in a newsletter or posted somewhere, or maybe even talked about at the next board meeting to let everyone know what exactly has been done. I thought I saw another question. Why does an association need a 209 policy if the specification with regard to these proceedings are specified in the Texas Code? All right, so the short answer to your question is the association doesn't necessarily need a 209 hearing policy because it's in the Texas Property Code. However, if you think about how many of your owners are actually going to go to the Texas Property Code and look up what the requirements are for the 209 hearing policy, in our opinion, and this is advice that we always would give our clients, it's always better to have a policy that's recorded, that's specific to your association, that is something that you can point to at the end of the day and say, these are our rules and regulations, and these are the rules and regulations that we have to follow. It makes it a lot more simple to just be able to go to your own policy. And then can the association change or modify how the proceedings are conducted? The proceedings need to be conducted at least in accordance with what the statute states. If there are some extra things that you want to put in there, you might be able to do that, but that's a question for your counsel. But I will say, for example, right now, the 209 hearing policy says that the association has to provide an owner with a packet of information that essentially proves up the violation prior to the hearing. And then the homeowner is supposed to be able to kind of go first during the hearing and talk about what their issues are, and then the association can respond or not. Those are just some of the things that are procedurally how the 209 hearing is supposed to go. But if there are some other things that you might want to do, then again, that's something that you need to discuss with your attorney. Yes, we will have these slides available. And I think that's it for the questions.
There's a couple more, Noelle.
Oh, okay.
So I'll read it to you. One asks, can you elaborate more on the Texas Property Code 5.006A relating to attorney fees?
Right. So essentially, if an association, and actually it doesn't say an association, it just says a prevailing party Whoever the prevailing party is in a suit for enforcement or some sort of administrative proceeding is the party that can be awarded recovery of attorney's fees. The statute itself is pretty simple, and so there's a lot of case law that actually deals with who's the prevailing party or who prevailed in the situation. But generally, that's one of the provisions that we use to make sure that we are able to recover our attorney's fees. But also with that, several conditions have to be met that are stated in Section 209. So for example, in order for us to be able to seek reimbursement of attorney's fees, we have to make sure that the homeowner has received or has been mailed a 209 compliant demand letter. So that means that it has to state certain things. It has to be sent by certified mail. It has to be sent to the property address that the association has on file or the last known address. Those things have to be done. And if they're not, there are no attorney's fees that can be recovered that come before the date when that letter is sent.
Okay,
I hope that answers the question. Go ahead.
One other question from earlier. Can they claim negligence if they are deemed discriminatory? I'm assuming that means talking about restrictions.
Can they claim negligence? I think, I'm assuming that you're talking about whether or not the homeowner can claim negligence. A homeowner can claim whatever they'd like. If a homeowner is filing a lawsuit against the association, or if they are responding to a lawsuit that the association has filed and they are asserting certain affirmative defenses, they can claim negligence. But negligence is really difficult because you have to prove that there was some sort of duty and that there was a breach of the duty and then that there were some damages. So the association's duty is basically their standard of care is like ordinary standard of care. There's no like fiduciary duty with single family residential associations or anything like that. So they have to kind of put forth whatever duty they think it might be and whatever the breach of that duty was. And so I think it would be difficult to link negligence with discrimination when it comes to enforcement of restrictions. Anything else, Kyle?
One more that's come in. So this is talking about a board member with a deed restriction violation. So if they build something and don't seek ACC approval and it becomes a deed restriction violation, how should the board respond, especially if they're working with other board members?
Okay. So a couple things. A board member should not be held to any different standard than the rest of the homeowners because ultimately the board member is a volunteer homeowner, right? So if the board member is not following the rules, then they have to be held to the same standard. The rules need to be enforced against them as well. Now, I would say that one thing that the legislation actually did help was it made a rule where board members cannot also be ACC members and vice versa. So the ACC has to be different. The ACC or the ARC has to be different from the board. And so that would help a little bit in this situation, right? Because the ACC doesn't have any vested interest. The other board members are coming together and kind of siding with this one board member who's in violation. But again, if a board member has not followed the rules, did not apply for a structure or built the structure without approval, then the enforcement actions that you would take against any other homeowner needs to be taken against the same board member.
All right, that looks like all we have, Noelle.
I think that was it. Okay. Well, thank you guys ever so much for joining us today. If you have any additional questions, please make sure that you send them over to me. You can reach me. My email is nhicks@rnwbh. I'm happy to answer any other questions that you might have. I appreciate you guys taking a little bit of time out to come and hang out with us today. And I did see a question about whether or not the slides would be available. Yes, we can make those available to you. And this presentation will be posted on our YouTube site as well. Thank you guys. Have a wonderful day. Enjoy the rest of your week. Bye.